So the admissibility of expert testimony is governed by Rule 5-702. That's the federal rule too, right, Steve? So a lot of states...
They're adding some, this is interesting because they're adding 6 through 10 here are non-Daubert factors that look like they're brought in by Federal Rules of Evidence 702. Daubert generally has five factors that the court is to consider. So, yeah.
So what a lot of states folks do is that rather than draft up their own rules of evidence and have debate and all this stuff over that, they'll essentially just adopt the federal rules of evidence, including the numbering. You see that all the time. So admissibility of expert testimony governed by Rule 5-702, which provides expert testimony may be admitted in the form of an opinion or otherwise if the court determines that the testimony will assist the trier of fact, that's normally the jury, but it could be the judge in a bench trial, to understand the evidence or to determine a fact in issue. In making that determination, the court shall determine 1, whether the witness is qualified as an expert by knowledge, skill, experience, training, or education. 2, the appropriateness of the expert testimony on the particular subject. And 3, whether a sufficient factual basis exists to support the expert testimony. So is he an expert? Is he testifying about something relevant to an actual issue in the case that needs to be resolved? And does he have the facts in evidence to come to a conclusion that would be relevant to an issue in dispute? Continuing now with the decision, trial courts analyzing the admissibility of evidence under 5702 are to consider the following non-exhaustive list of factors in determining whether the proffered expert testimony is sufficiently reliable to be provided to the trier of facts. 1, whether a theory or technique can be and has been tested. 2, whether a theory or technique has been subject to peer review and publication. Man, if people only knew how weak peer review was. 3, whether a particular scientific technique has a known or potential rate of error. 4, the existence and maintenance of standards and controls. 5, whether a theory or technique is generally accepted. And then I guess we get to the extra ones that Steve was referencing. 6, whether experts are proposing to testify about matters growing naturally and directly out of research they have conducted independent of the litigation, or whether they have developed their opinions expressly for purposes of testifying. 7, in other words, whether the testimony is just bought. 7, whether the expert has unjustifiably extrapolated from an accepted premise to an unfounded conclusion. 8, whether the expert is adequately accounted for obvious alternative explanations. 9, whether the expert is being as careful as the expert would be in the expert's regular professional work outside the expert's paid litigation consulting. And 10, whether the field of expertise claimed by the expert is known to reach reliable results for the type of opinion the expert would give. In applying these, so all of that is, let's see, factors 1 through 5 are from a Maryland court decision, probably a Supreme Court decision.
Which is the one that brought it over from Fry to Daubert. So it's basically those are Daubert factors.
Right. It's Maryland case of Rochekind is quoting from Daubert for factors 1 to 5, and then next quoting the Federal Rules of Evidence 5702 for factors 6 to 10. So they call these now Daubert-Rochekind factors. I'll just refer to them as Daubert, folks.
And can I make a point here that this is one of the most this is almost a U.S. Supreme Court decision, and I really am impressed by the level of detail and structure that the judges in this case do, because this is exactly the way it should be done. It's very well organized. So what you have here is you have these factors. So say, okay, here's our test that we've set up beforehand, our objective test. Now we're going to go through the rest of the cases, taking these factors and looking at them individually and analyzing what the evidence is to these different factors. So what you're going to see going forward now is they've listed the factors. Now the court is going to apply those factors to the different to this particular science, or this faux science, this bullet matching science.
Let's see. In applying these Daubert factors, we have observed, lost my place here for a second, observed that the guidance provided by the United States Supreme Court in Daubert and its progeny is critical to a trial court's reliability analysis. We previously summarized that guidance in 5 principles. 1, the reliability inquiry is a flexible one. 2, the trial court must focus solely on principles and methodology, not on the conclusions that they generate. Much like how I feel about criminal procedure, about due process of law. You ought to care about the process, not the outcome. However, conclusions and methodology are not entirely distinct from one another. Thus, a trial court must consider the relationship between the methodology applied and the conclusion reached. I don't know what number I'm up to. 3, a trial court need not admit opinion evidence that is connected to existing data only by the ipse dixit of the expert. Rather, a court must conclude that there is simply too great an analytical gap between the data and the opinion proffered. 4, all the Daubert factors are relevant to determining the reliability of expert testimony, yet no single factor is dispositive in the analysis. A trial court may apply some, all, or none of the factors depending on the particular expert testimony at issue. 5, Roshkind did not upend the trial court's gatekeeping function. Vigorous cross-examination, presentation of contrary evidence, and careful instruction on the burden of proof are the traditional and appropriate means of attacking shaky but admissible evidence. The overarching criterion for the admission of relevant expert testimony and the goal to which each of the 10 Daubert-Roshkind factors and the 5 principles we just described are all addressed is reliability. The question for a trial court is not whether proposed expert testimony is right or wrong, but whether it meets a minimum threshold of reliability so that it may be presented to a jury, where it might then be questioned, tested, and attacked through means such as cross-examination or the submission of opposing expert testimony. Because we evaluate a trial court's decision to admit or exclude expert testimony under an abuse of discretion standard, our review is necessarily limited to the information that was before the trial court at the time it made the decision. A trial court can hardly abuse its discretion in failing to consider evidence that was not before it. So all of this is really speaking to a minimal floor of quality of the expert witness testimony, the evidence the expert's working with and what they plan to say about that evidence. It doesn't have to be perfect quality, but it has to be above a minimum floor. If it's above that minimum floor, then you can have 2 different versions of scientific expert witness testimony that the jury has to decide which one they find most credible. But you don't want the jury doing that analysis if the evidence falls below a minimum floor of quality.
Well, and David in the chat makes a good point, is that when I read this this case, it is almost a de novo. They are saying, which it's even better for us people who criticize this ballistics firearm matching garbage as junk science, when it is reviewed as abuse of discretion, because that is a much higher hurdle to get an appeal done. So they are saying, well, and
no reasonable judge could have come to this conclusion.
Right. This is an abuse of discretion for this judge to have allowed the jury to hear testimony that this Ferry bullet was fired from this very gun. That's what they're doing in this case, which is a much higher par than looking at it cold, fresh. So that's even better for people who want to challenge this type of junk science.